This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night, so call in your questions on any legal subject. Maybe you've been in a car accident. Maybe you've bought a product that hurt you. Maybe you've got a loved one in a nursing home and you're worried about the care that they're giving. You're asking, how do I protect them? And what do I do to be sure that they're being provided for? Call in the 31 Law Call number, 256-536-0077. You can call in and be live on the air, or you can text us to that same number. We have some of your text questions tonight. You can also email us. You send an email any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we pull out some of your questions. We've got some of your emailed questions tonight. Michael Timberlake's here from Timberlake, League & Brooks. Good to have you here.
It's great to be here.
Ask Us Anything night. So your office, you do all kinds of personal injury cases. So
Sure.
That's car accidents. What is that?
Car accidents, medical malpractice, workers' compensation, slip and falls. We do business fraud. We do bad estates. We do a little bit of everything.
Okay.
So that's why we can do this and, kind of answer everybody's questions. We'll do the best we can with questions that are in our area. And But I've been doing this for nearly 30 years, so I kind of have an idea about what I'm talking about.
Folks talk about PI work. That's
Right,
what personal
that's what we do,
injury.
right.
Okay. So we'd like to get you started off with some video. We've got tonight's You Make the Law Call video. We see it from two different viewpoints. We see it from the outside of a bus. Is it a bus or a train? Because I've seen the inside of it. Looks like it's going to be pretty bad. A vehicle is coming, runs the red light out of nowhere. We may have to take just a minute. We'll come back to it. Okay. We're going to skip that for right now. Let's take one of our email questions.
Yeah.
So Jerry had written, if police pull you over, do you have a legal obligation to show your license or to answer any of their questions other than name and address, or can you just tell them to stick it? Yeah, you can't do that and you'll get arrested. You can. But
you actually can. It may not turn out the way you want it to. I mean, basically in Alabama, what the law says is that if you are pulled over, they can ask for your license. You don't have to talk to them, but there's some basic documentation that they're going to get. If you don't provide that information, then they're going to be highly suspicious of what's going on, and it's probably not going to turn out right. So basically, you have to cooperate in some way. Now, you don't have to consent to a breathalyzer or field sobriety test or even the Drager, which is the breathalyzer test, when they take you to the station for suspicion of drunk driving. So you can just say, no, I don't want to do that. But under Alabama law, you automatically lose your license for 90 days by failing to consent to the Drager test.
so weigh it. Might be in your best interest.
Absolutely, and you have a right to get a blood test too. So you can say, look, I'm not going to not going to participate in this, and then they'll have to get a warrant to get a blood test.
Okay, what about if they say, I want to search your trunk?
You don't have to consent to a search for a trunk or your vehicle. If now they can make up some probable cause, or they can make up some reasonable suspicion. Say they smelled something, or say they saw something, and search your car. But that's obviously the first thing you would do is not give them permission to find potential evidence in your vehicle.
We got in a text question from Kit. Kit says, I got a letter in the mail after an accident. Says if I don't pay him $10,000, they're going to sue me. It sounds like blackmail. What do I do with that?
Well, I mean, it's not blackmail because it's perfectly legal for somebody to file a civil suit against you.
Okay.
So it's not necessarily blackmail. If you have liability insurance, send the letter to your liability insurance carrier. If you're in a wreck, you need to contact your insurance carrier and just tell them, look, I was in a wreck. Put them on notice so that they'll be in a position to be able to handle it if and when the time comes for them to handle it. But if you get a letter from an attorney or the other party or whatever, and you have insurance, you need to contact those people. If you don't have insurance, then the question is, do you want to go out and hire a lawyer to talk to this other lawyer, or do you want to try to handle it yourself? Sometimes that's not the best idea.
We got this text question. If there isn't a will, how long do you have to close the estate?
I don't think there's any limitation on time period to close an estate. And definitely not based upon whether there's a will or whether it's an intestate estate. You have 5 years from the date of death to file a will, so that if you have, file for probate, file to open an estate, that's going to be a hard time period that you need to, take into consideration. But once you've opened an estate, unfortunately, it can take some time to, dispose of property of this, that, and the other, and there is no time limitation on keeping an estate open.
Okay. We've got Betty on the line with a question. Hi, Betty. Thanks for calling in. What's your question tonight? Hey, Betty, are you with us?
Yes, I sure am.
Hey, Betty, what's your question tonight? Thanks for watching.
I got divorced here a few months ago,
okay.
And when the papers was filled out, the wrong wedding date was put down.
Okay.
Is that legal?
So I do family law, and we find mistakes frequently. Things will just slip through. So it's probably not going to be a problem. Did you do an uncontested divorce, or what kind of divorce did you do? Y'all agreed on things?
Now, ma'am, I didn't understand you.
Did you file uncontested, so you filed a settlement, or did you actually have a trial?
It was uncontested.
Okay. Probably, if you'd like to clear it up, there are some ways that you can file a motion with the court and just say it's a clerical error. And even if it's outside some time limit windows, they'll let you fix a clerical error. It'd be nice to have those papers looking correct, but it's not going to throw out the whole divorce. I've never seen anything that actually caused a problem with having one little date like that wrong.
Yeah, I had a situation like this with a client, and she was trying, I can't remember exactly what she was trying to do, but she needed to have her divorce judgment corrected because they had the wrong dates in that, and we were able to do that fairly easily.
Yeah.
So
it would be important if it's something like a retirement plan or things like that, it would be worth going to fix them, okay?
Absolutely.
We got our video back up. Let's take a look at this video. We pulled something off of YouTube. So you see the truck coming through right there, okay?
Yep.
We don't know what caused him to miss the light, whether it may be a medical emergency. Now you see the folks inside the bus.
Oh.
So everybody survives, and not too injured. The folks sitting right back there to the left, though, I think surely that's who got the worst of it.
Right.
When you see something
they saw
like
it
that,
coming.
Yeah, thank goodness this man got out of the way.
Right.
And we see him moving around afterward. When you see something like that, what are you thinking as a personal injury attorney? What if it is a medical emergency and the truck driver, he didn't certainly mean to? Does that mean there's not a lawsuit?
Well, I mean, so obviously it's a violent impact, and you wouldn't want to think that anybody would do this just by normal carelessness, so that they just didn't make a mistake. There's something else going on here. But if you have if a person has a legitimate medical emergency, which is something that they did not know or did not predict was going to happen, then it is a defense to a claim that they operated a vehicle negligently. So if you have, we've had claims against people that have seizure disorder that had been warned not to operate a motor vehicle. They had a seizure, caused a wreck. Well, certainly that's a claim that you'd be able to make. But if it's somebody that maybe had controlled seizures, had had a seizure in 5 years, was on medicine, the doctor said, yes, you can drive, and then they have a seizure, that's a little bit different story. If someone just has driving down the road and has a, blood sugar or has a, heart attack, is probably the most sudden thing, because it's not one of those things that you see coming on like some other kind of other problems with medication or diabetes or things like that. So it can be used as a defense to negligent actions.
Can a family be sued if a loved one, like you've got a senior family member who shouldn't be driving anymore,
right,
and you know that and you don't do anything about it? Can the family be sued? Well,
you don't have necessarily an obligation to, be sure that everybody in your family is a safe driver.
Okay.
If you have a minor or someone that you can, that you have, control over, and you're aware that they're incompetent, then, which is unable to operate a motor vehicle safely, then you could potentially be held responsible for negligent entrustment. But if you got somebody that's been driving all their life, they own their vehicle, they just live in the same household with you, and you don't take action to take away the car, that's going to be a little bit different. If you loan them your car with knowledge that they're incompetent, that can be a bit.
Okay. We've got Renee on the line with a question from Harvest. Hi, Renee. Thanks for watching and calling. What's your question tonight?
Hi, thank you.
Sure.
So I had a question about development fees.
Okay.
So, you know, Huntsville is growing and there's all types of areas being developed and stores and things popping up everywhere. So I noticed on some of my recent receipts, one that was a substantial amount, that in addition to the taxes, there was an additional line item for development fee on there, and it wasn't something that I could, you know, scratch out, decline, or whatever.
Right, like a tip. You couldn't say no to it.
Yeah, it's like the mandatory gratuity type thing. So,
And this is just in a regular store? Just any old store?
Yeah, I
tell
don't know
us
if I
where,
can say the name of the area, but
Yeah.
Oh, it's in Madison. It's there are a lot of people
you've heard
talking
of this?
about
Okay.
it. Yeah.
yeah, it's
How
out
can
that
they
way.
do that?
Well, it is basically it's a fee for being on their, you know, it's like you're charged to be on their premises. So it's like you go to Disney, you have to pay for admission.
Okay.
You want to go to Costco in Madison, you got to pay for admission. You know, there's are some of those other stores out there. It was something that the developer put in place with the city, and it is something that they do collect. Now, I think the city gets some compensation because they're actually the people that are collecting the money for the developer.
The city is collecting it. Okay.
So there has to be some kind of legal agreement between the city and the developer as to, you know, who's paying for the you know, what the development fee is going to be, and then who's collecting it, and then how it gets paid out to the developer. And if the city's collecting it through tax receipts, then, you know, obviously the city would get some kind of compensation for that. Not completely aware of all the specifics on how it works, but it is, you know, obviously it's a legal situation.
Would make me want to, if it's a pretty significant purchase, it might be worth driving into a different part of town.
I thought the same thing, and I said, well, I just won't do that.
Yeah.
And then I thought about it, and then somebody said, well, you know, the sales tax in Madison's only 7%. Sales tax in Huntsville's, you know, 9%. The developer fee for this one particular store is 1.2%.
So you're still better off.
1.5%. So
You're
you
still
may be better.
off. Okay. They're telling us to take a break. We're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night. We've got a lot of texts and a lot of questions waiting. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. It's Ask Us Anything night. Michael Timberlake's here from Timberlake, League & Brooks, and we've got callers waiting. Haley's on the line, waiting from Florence. Hi, Haley. Thanks for calling. What's your question tonight?
Hi. Thank you for having me.
You bet.
I'm an avid fan.
Thank you.
Thanks for watching.
So I moved to Florence, Alabama. I changed schools. I moved up here from Tuscaloosa, and I got a job at a local restaurant. I worked a total of 4 shifts. And then I was told, or I wasn't even told, I saw a Facebook post on January 20th that the restaurant was permanently closing on January 25th. Is there like a law of an amount of time they're supposed to give me to find another job? I mean, I literally found out through a screenshot post that my friend sent me. My manager did not contact me, and we had 5 days. There was no warning, nothing.
Gee.
So, you know, unfortunately, it's legal to be really, really uncool and do that to people.
Yeah.
You know, in Alabama, we're a termination at will state. So you could be hired or fired for good reason, bad reason, or no reason. So they don't have to give you a good reason, but if they're closing, that's pretty much the reason that obviously is going to be the most, you know, compelling. But small businesses don't have to provide advance notice of layoffs. Larger businesses do. There's some protections there for, and I can't remember if it's 25 or 50 employees, but if they're going to lay off a certain number of employees at a certain time, then they have to give advance notice to those employees. But in a small business like that, unfortunately, you know, they should get you together and say, hey, we're really sorry, and not just post on Facebook. But unfortunately, that's not the way that a lot of people handle their business.
So if you had damages, like if you quit your past job to take this job, or you sold a house to move here, and
Sure.
and could you sue them over something like that, damages?
In the absence of some kind of employment contract. You're a termination at will employee, and they're not responsible for any damages. Now, and then it becomes a question about, did they commit fraud when they hired you? And that can be a little bit of a different situation. But you've got to prove, it's called promissory fraud. If they promise you something to get you to act on it, and then they don't come through it, in order for them to be responsible, you've got to prove that at the time that they made the deal, at the time that they encouraged you to come here or told you that we were going to do this and we were keeping you on, or this job would be available, that they knew it wouldn't be available and that they were going to ultimately terminate you. And that's a hard thing to prove.
It's tough. Okay, we got this text question. If you get hit by a car and you settle on the case, and you're on the verge of losing a kidney. Okay, so this one was serious.
Right.
Does the insurance company have to pay for that?
We tell everybody, look, liability claims are a one bite at the apple situation. You only get to make one claim, you get one lump sum of payments, and then you sign the release, and then the insurance company is forever released from any responsibility. And typically the releases say, you understand that your injury could be better or could be worse than you think it is, and there will be no more money coming. So unless there was some specific provision written into the release that they are responsible for future medical benefits, then they are not going to be on the hook for that. And in a liability situation, that's pretty rare. We see it in workers' compensation. The law requires medical benefits to be left open, but in car wrecks, it's fairly rare. Although we do see insurance companies trying to get out there and say, oh, we'll pay for your medical bills for 6 months and give you $500 in cash if you want to settle. And we think that's probably a bad idea.
Okay. We got this text from Ann. Ann says, I live in an independent senior facility that's full of mold. The owners and managers are aware of it, and they continue to move unsuspecting seniors in, and they're not moving the mold out. What can we do? Please help us. We're all suffering from mold-related illnesses, and nobody seems to care about that. They just want our rent.
Right.
Can you do so senior living?
Well, I mean, it's difficult because you get the situation. You've got to prove that your illnesses are a result of this mold as opposed to some other mold that's in the environment. That's kind of the big hurdle that we look at in these situations. And then you have to prove that it's not habitable, that that your situation is uninhabitable. And unfortunately, the Alabama Landlord-Tenant Act basically says your remedy is to be able to cancel your lease and move out. Now, if it is some public subsidized housing through, the federal government or some kind of Section 8 type thing where there's a rent assist housing, there are some provisions in there that you can go through the federal government to make them update the premises to make it livable, and that's just one of those things you'd have to look at.
Okay. Was it Nicole? We have Nicole. Okay, I think we lost her.
Uh-oh.
Another text message. A friend of mine nearly died as a result of a drain tube being left in her gallbladder after a fall 2.5 years ago. It caused it to fuse with her liver.
Oof.
Okay, so she says, is that the kind of case, is that a medical malpractice case? What do you have to prove to deal with something like that?
Yeah, I mean, one is, I think more than likely the drain tube that they're talking about was the stent that was placed that was probably supposed to be permanent.
Supposed to stay, okay.
So I'm not sure that there would be anything there. But in general, in a medical liability case, what you have to prove is that the doctor or the nurse or the hospital did something that no reasonable doctor, nurse, or hospital would do under the same circumstance. And you have to have an expert. You have to have a nurse or a doctor come in and say, these healthcare providers did something that no reasonable healthcare provider would do, and that it directly caused this damage. These cases are complex. They can be expensive to pursue because of the expert requirements, and some of the liability carriers or the insurance companies involved in these cases will try most of them to a jury because they win. So these cases are incredibly fact specific, complex, hard to win, but you know, we do look at them, and I look at a lot of medical records and to see if there's something that we can, you know, recover for somebody.
First step, get your medical records and take it to a lawyer.
Yeah, absolutely. First step is get your medical records. People, lawyers like us, we do initial consultations. We can look at the records and generally tell you pretty good idea about whether it's something that we need to explore further.
Are they going to have to pay for that consultation for personal injury kind of cases?
We look at a lot of cases. Initial consultations are always free in that situation. If we take the case, we work on a contingency fee basis. So we put all the money and time into it up front. If we recover, we get paid. If we don't recover, then we're not paid at all. So it's a high risk, high reward type proposition.
Okay, somebody's texting in, my grandfather made me power of attorney, but now he's died. So does the power of attorney still give them powers to do things?
Power of attorney is a document that you sign during somebody's lifetime that basically gives another person the power to do anything that you could do. Move money, sell property, you know, anything, any kind of transaction. But it is only valid during the person's lifetime. Once the power of attorney is, once the person is dead, then the power of attorney goes away. The power of attorney doesn't give you any more priority or benefits after someone's passed away. So it doesn't mean that you're going to be the representative of the estate or you're designated as that. It just means that during lifetime you have that power.
Okay. I want a judgment in a car accident case. The defendant won't return my calls. How do I collect that money? How many of those cases do you have? Win a judgment, but collecting is something else.
We've been there before. You know, a judgment is one of those things that it is a legal paper that says you're entitled to this much money. It doesn't mean that the other person has to has to come voluntarily to your home and pay you the amount of money. If a judgment is it's not being paid, then you can, file, an action to execute on the judgment. But mostly, probably the best thing to do is try to, garnish somebody's wages. So you can, hire a lawyer to find out where they work, and then you can garnish their wages till your judgment is paid.
We're going to take a break. We'll be right back answering more of your questions. It's Ask Us Anything night.
It'll be fine.
If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake with Timberlake, League & Brooks in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And Sharon practices family law right here in Huntsville in the North Alabama, 256-539-7337. SharonFamilyLaw.com.
In the news this week, there was a gun in a school, a second grader maybe, a gunshot, and thank goodness nobody was injured. I think it hit a laptop instead. If somebody gets injured with something like that, is that a lawsuit?
Well, I mean, yeah, you're looking at something. Obviously the child would be somebody that would be responsible, but kids are presumed not capable of negligence at a certain age. I think this was an 8-year-old. So then you look to the parents. You say, okay, did these parents do what reasonable parents should have done to protect this gun from being, taken to school by their kid? And I think the legislature's looking at some more serious laws in terms of pushing that liability, but it's definitely something that they could be held liable.
We'll see you next week. Thanks for your questions.